So before Jeff gets started, I'm just going to tell you all about our newest program in case you haven't heard of it. We just launched our contract roundup program at the end of July, summarizing contracts and essential data from those contracts that we received throughout the MBH and district title footprint throughout the month. So this is giving you trends and insights into how the contracts are being accepted in your local markets, and putting them into a beautiful infographic so it's easily digested, and then you can go on and share with your clients and your colleagues. So how to get this information? We have a sign up on our website under Contract Roundup. Put your email address in and you will be subscribed to our newsletter. We will be coming out with the information monthly and hope to develop the program more. So we're very excited to share. And the best feedback that we got on the program was someone said it was better than Netflix. And then we also got a virtual woohoo in our inbox about the program. So we're looking forward to sharing that. And I will let Jeff go ahead and get started.
Thanks, Bev, and thanks for organizing this for us here today. I know there's been a lot of interest in relation to all the forms updates that have been going on. And again, I'm Jeff Darrah, the managing attorney here at District Title. And for those of you that aren't aware, District Title is part of the larger MBH settlement group. And as part of our group, District Title, our brand focuses on transactions in DC and Maryland. We also do Virginia, West Virginia, Delaware, and we also specialize in our commercial and investor transactions. We have a whole team of attorneys and their staff that solely manage those deals that range from large commercial transactions and shopping centers to your local investor flipper. Our main office in district at District Title, we get a lot of questions on that, is here in Farragut West, where I am here today, but we have staffed and satellite offices just about everywhere in the DMV. So thanks again for joining us. Thanks again, Bev and the marketing team, for putting our event together, and we can go ahead and get started. As all of you know, our realtor world has been dealing with this NAR settlement and all the fallout that has stemmed from it. As part of the settlement, our industry has been busy educating ourselves on all the new forms and procedures being put out by our local realtor associations. And today we're focusing on those latest GCAAR form updates that were released in July. And we just want to make clear that while these forms are ready for use as of this moment, they are not yet a settled issue. So we'll continue to look out for guidance and continue to look at how the situation develops. And we'll do follow-up education as the forms and procedures continue to update in the coming months. But GCAAR's aim with these form updates is to be as transparent as possible, to be super clear, and to serve our agents and to allow you to continue doing the outstanding work that you do in the community. So just a quick disclaimer here, our team in GCAAR doesn't represent any parties in that litigation or in the settlement, and we don't here at MBH and District Title represent any particular realtor association. We're just here to explain the ins and outs of the forms as they come across and try to make your lives a little bit easier as you implement these in your day-to-day efforts. So I will move on to our next slide, which outlines the different forms we'll be talking about today. There are a number of revised forms, and we'll go through all of these in detail, and there are 3 brand new forms. We'll put copies of all of the forms in PDF version in the webinar chat, so you can pull those up if you're not already familiar with those. And I'm going to start today with our revised form 875. Pulling up our screen now. This is the buyer acknowledgement of offer terms. Some of you may be familiar with 875. This form was previously called the potential adverse consequences acknowledgement. And the purpose of this form is to facilitate a conversation between the buyer and their agent regarding potentially risky decisions your buyer may wish to make. It provides spaces in the form here that the buyer can initial off if they wish to make the following decisions in their terms of offer. Those can be things like if the offer price is higher than the listing price, if they would include a price escalation clause in their offer, or if they want to waive certain contingencies like the financing contingency, appraisal, home inspection, the right to negotiate a home inspection contingency, radon test, lead-based paint test, a private water supply system, on-site sewage disposal system, or sale, settlement, lease of home contingency, or termite and wood destroying insect inspections, for example. The changes here have been, one, the name has been changed. The title was changed to reflect an alignment with another form we're going to go over here in a moment, Form 876, which is the seller acknowledgement of declined options. So we have a similar form now for both the buyer and the seller to check off on certain decisions they may want to make, that the realtor wants to protect themselves and cover themselves if there's some later issue that comes up. A second change in this form here, our language in paragraph 1 has been edited to clarify the purpose of the form, and some of the terms have been updated in the checklist below with a more positive connotation. GCAAR's position was basically that they didn't want to take the position that these buyer decisions were being placed in a negative light. It's not GCAAR's position to determine whether a decision buyer makes are adverse or not. So they added a more positive connotation to those. And a third change here is they've added two brand new acknowledgements that the buyer clients can check off. These are the waiver of a right to negotiate the home inspection. And this complements the waiver of the home inspection, since those are two actual different options now. And acknowledging when the seller's offered cooperative compensation is less than agreed upon in the buyer broker agreement. We'll go over that form here momentarily as well. So in this form, this covers a lot of the talking points for you'd have with your buyer clients. In those events, situations rise, and these are the options that you can check off that they've made that may have an adverse consequence. It's a recommended GCAAR form in both Montgomery and DC. And a lot of our agents inform us that they had rarely ever used Form 875 in its previous iteration, and they don't intend to use this form in its new iteration, and that's totally fine. It's not a part of the contract package. It's not required, not a requirement. It's just a form that's here for you if you want it, just to be a part of your available tools in your toolkit and directing conversations with your clients. So Form 875 has been revised. And that can take us on to our next updated forms, which are Forms 910 and 920. And these are the listing agreements we have for improved and unimproved real property and cooperatives. In each of these listing agreements, paragraph 6, which is the entry into Bright MLS, I will pull up here, has been updated to reflect the new rules for the submission of property information into the MLS, including updates that will take effect this month in response to the NAR settlement we were referencing a moment ago. So these changes regard the rules for submission to Bright MLS, and they include new policies for properties that aren't yet ready for public marketing. So you can see here in section 6, they divided these up into a public and non-public limited marketing and added this new pre-marketing status. So we now have these 4 choices for the status of our properties. Those are pre-marketing, coming soon, active, and this limited office exclusive status. And in each of the 2 listing agreements, paragraph 7, which relates to broker compensation, has also been updated. So I'll pull that up. Paragraph 7 regarding brokering compensation has been updated to reflect possible terms and offers of compensation between parties involved in the transaction. And these changes reflect GCAAR's efforts to do what NAR asked them to in the settlement, which is to separate the compensation paid to the 2 sides. So here you have the listing agent's compensation separately listed, and then you have additional spots where you can put in information for additional listing agent compensation. If you're working with an unrepresented buyer, for example, compensation offered for a buyer's broker, and compensation offered for a sub-agent if one is involved. So those are the big changes to our listing agreements that will accommodate our representation for how each side now is going to be paid separately. And in relation to our listing agreements, we just want to clarify a couple things. First, Bright has come out with a brand new form. It's noted here in bold in the box in section 6. It's been in usage for several weeks now, and there's a lot of information in this Bright MLS form that must be included in both your listing packages and your buyer broker agreements. And it talks all about the ins and outs of Bright, and what's noted here in the form is that it must be included. Again, it's required. It's called the MLS Disclosures and Residential Seller Landlord Options. This form currently needs to be pulled from the MLS itself. It's not currently located in the GCAAR Forms library. This may very well change in the future, GCAAR tells me, but as of right now, it needs to be pulled directly from MLS. Second, we want to note that Bright has introduced this brand new category called pre-marketing, we noted a moment ago. And this has been a source of a lot of conversation. You'll see this category is only for listings that you may get signed and ready, but have no current intent to market or do anything else with the property yet. So that would be considered a pre-marketing property status, and they've now given you the choice to call your listings pre-marketing while you hold on to them and not submit them to Bright quite yet until you're ready to do something with them, at which time you would move them to active coming soon or an office exclusive category. So those are changes to our listing agreements for improved and unimproved properties, 910 and 920. And with that, we can move over to forms 1301 and 1306, which are GCAAR sales contracts. Not too many revisions on these. The changes to both of these versions of the contracts for improved properties and for unimproved real property are essentially the same. The general sales contracts here used primarily for improved properties has been updated in paragraph 19. Back to our highlighted points here. Paragraph 19 regarding the broker's fee has been amended and updated to reflect our new guidelines and best practices regarding the new offers of compensation. Basically, it's been amended to reflect the irrevocable authorization to the settlement agent, the title company typically, to pay the broker's compensation at settlement as set forth in the parties' respective brokerage representation agreements and any other broker compensation addenda that's made a part of that contract. So when we get to these new forms, you'll see that the broker compensation agreements look like this. And then in the unimproved contract 1306, the updated paragraph is 16 and the language is essentially the same. So in essence, these updates make it very clear to our clients and to the settlement attorneys where their responsibility lies as to the payment of compensation in case there's any questions under this new regime that the parties are to be paid separately and in regards to the compensation noted in their respective agreements with their own parties. With that, we can move to our next updated form, which is 1339, our addendum of clauses B. Here, GCAAR has added specific language and updated our language in paragraph 7, pulled up on the screen here, to reflect that we're now talking about the payment of compensation now and not commission. You'll see here and really on all the forms we'll go over today that the word commission has been essentially removed and stripped and replaced by compensation. Additionally, this updated language makes it clear that it's best practice to have all information related to compensation in front of the buyer before you show the first property. That's 1339. Next up in our list, form 1341, which is our buyer agency agreement. Here, the buyer broker agreement has been updated to reflect new guidelines and best practices regarding compensation, including its removal in its entirety from the Bright MLS. As we talked about previously, the goal here was to separate and decouple these, if you will, so the buyer can now choose to either be obligated for the payment of compensation at closing or choose to request seller payment and/or contribution if they're so generous to do so. Regardless of that choice, the buyer does remain obligated for that compensation due if the seller elects not to compensate the buyer broker. And truthfully, if we read these agreements in the contract previously. That's how it always did read. We're just now really going to be sticking to the language of the contract. And we have two very important other notes. First, our agreement here states that any seller offered compensation to the buyer agent will be specified in a further addendum to the purchase contract. We'll see that here in a moment. It's a brand new form they've added. And second, it also states that the total compensation from any source or combination of sources may not exceed the amount or rate agreed to in this buyer agency agreement. The form is also updated to specifically reflect defined terms and parties as outlined in the introductory paragraph of the form here in front of us. For those that are interested, we have a red line version of the form. These slides will be made available. It's very rare that GCAAR allows dissemination of red line versions of their documents because of the major changes involved. They've made an exception here. So for those that are interested, you can pull up the slides and really see word for word what GCAAR amended to reflect these new compensation changes due to the importance of these latest updates here. So you can see here in a red line version what changes are illustrated, what they are, and how they were incorporated into the form. 1341. Next up in our list is a sole form change relating solely to Maryland, and it has nothing to do with the NRA settlement. This is Form 1367, the escrow agreement between the buyer, seller, and the non-broker escrow agent. GCAAR updated this form in conjunction with the MLTA to comply with the Maryland law that went into effect October of last year. And we do really appreciate this form on the title side of things, and we do use it on a regular basis. It's reflecting this new law that went into effect last year. It's been moving across the country, so we may see similar laws put into effect in the jurisdictions like DC and Virginia. It addresses a problem that we often have on the realtor and title side of a buyer-held earnest money deposit, where a buyer needs to get out of the contract for a valid contingency or other reason, but we have a seller who is hesitant, not willing, or able to sign a release, and that escrow can be forced to be held in escrow with the title company for longer than it should. It provides a leverage and mechanism for that buyer to request and demand that that EMD be returned and refunded to them. So again, it provides a mechanism for our escrow agents, typically the title company, to return the earnest money deposits back to our buyers when the buyer terminates the sales contract based on acceptable contract contingency. So essentially in the event of a unilateral termination of contract, and the only exception is if the seller happens to file a claim in a specified time frame. Otherwise, the escrow agent must release those earnest money deposits to the buyer. So new direction to the escrow agent and how to disperse EMD funds in the event that the sales contract is terminated lawfully and this buyer is not in breach. So relatively simple change here that you'll see on your new forms for Maryland. Next up, we have Form 301. This is our seller paid buyer broker compensation notice. So this form was created in response to the removal again of the compensation from the MLS. GCAAR knew that listing agents would be concerned about buyer agents besieging them with requests for how much, if any, the seller might be willing to pay the buyer broker compensation. So they've created this simple notice that listing agents could send out to all the buyer agents interested in showing the property prior to the initial showings of the property to provide them what, if any, the seller was willing to contribute to the buyer broker compensation. It's used as a confirmation and documentation of that seller offer compensation again to the buyer broker. And the intent here is to have a clear and transparent conversation with the buyer about compensation prior to showing the property. So it's recommended that we make this notice available to all of our buyer brokers and prospective buyers before being shown a property to specify the terms of compensation. And to review it before the showing, we'll properly initiate the conversations that need to happen with our buyers about any responsibility they may have towards compensation per the buyer broker agreement, if not covered by that seller offer of compensation. So you can see here how GCAAR has broken it out to align with the listing agreement as to what, if any, the seller is willing to contribute in the form of a percentage of the sales price or a flat dollar amount or some combination of the two. And it'll be signed by the listing agent, our listing broker, and seller, and given to, again, the buyer agent upon their request. And one of the top questions that comes up around the discussion of Form 301 is what other methods the listing agents and seller side can use to get their compensation offers communicated out there to the buyer side. And the short answer is just make sure that no form that includes compensation or numbers are put into the MLS. How you transmit it otherwise can be done in really any other method, by email, fax, regular mail, etc. It can really be done any other way or form that you choose, as long as it's not loaded into the MLS. All those compensation fields and information were removed from the MLS starting yesterday. And another top question on this Form 301 notice is whether it's required. So it's not required. Agents are free and welcome to use their own notices or method of notice to the buyer side if they choose. This Form 301 notice is just provided by GCAAR as a tool to assist us. It goes in tandem with the later compensation addendum that will be added to the contract, 1302. We'll see that in a moment. And as a side note, we always do advise on the title side that our agents use GCAAR forms and addenda and notices if you're in the GCAAR contract universe for your transaction, using a GCAAR compensation notice and the final GCAAR addendum. They're made, the language is made and tailored to go in tandem and work together. So we wouldn't typically want to advise that agents use, say, a MAR notice and then a GCAAR addendum to the contract relating to compensation. They're just not meant to work together in that way. And our next form we can go to is 876. We referenced this early when we looked at the first document, 875, the related buyer acknowledgement of offered terms. This is the seller acknowledgement of the client options. So this is the brand new seller form 876 we referenced at the outset that complements form 875, which is the buyer version. Here in form 876, we list out the options. These are taken directly from our listing agreement, and they allow the seller to acknowledge and reaffirm the choices that we've counseled them on the realtor side of things, and that may have potentially negative impacts on the ability and efficacy of the marketing of the property. These include decisions like opting not to list the property in the MLS, deciding not to use a coming soon status, not offering compensation for our cooperating brokers, the use of a lockbox or installing a for sale sign on the property, and the option for holding open houses. All of these, and all of which can, one way or another, impact the ability of our realtors to market the property properly or well. And again, these options have been taken straight from our listing agreements. It's certainly not an exhaustive list, so GCAAR has added here this other category at the bottom for our realtors' specific needs. And just a reminder here that this, again, is not a required form, is not to be included in the contract package or submitted to other agents, but definitely another tool in your toolkit to help you and guide you with your conversations with your clients about the decisions they're making while listing their home for sale. So another new form here to consider using as a tool, and hope it serves you well if you choose to use it. Next up, we have Form 1302, and this is that final contract addendum we referenced earlier, the addendum for seller to pay buyer broker compensation. So we referenced this addendum in the initial notice 301. So 301 is that initial notice put out there by the seller saying what they initially offered to pay, if any, for the buyer broker compensation. And the final addendum, once the final seller paid compensation, if any, is negotiated, this burns that agreement into the contract as a form of an addendum. So in this addendum, again, the mere suggestion of seller offered compensation that we saw in the initial notice, Form 301, is solidified and incorporated into the contract with finality in this Form 1302. And this is the second brand new form that addresses compensation on the listing and selling sides, clarifies they had been wholly separated. And so as part of these changes, compensation on the listing and selling side have been fully separated in all of our forms. And along with Form 301 offering the terms of compensation in the contract, this form, 1302, is to be filled out and used to provide an opportunity for a buyer to ask the seller to compensate buyer broker directly at closing. And this form will go along with your offer and your ratified contracts. It's very easy to fill out. As you can see, it's agreed to and signed by the seller and buyer. And we have a lot of questions on this form. Form 301, the initial offer of seller paid compensation. Between Form 301 and this final addendum, there is welcome and the intended to be the ability for the buyer and seller to further negotiate if there's any disagreement or discrepancy between what the buyer offered to pay in the buyer broker agreement and what the seller is offering to pay in that Form 301. The two sides are welcome to negotiate and come to a further agreement in this Form 1302 that is attached to the contract. Just the highlights of Form 1302 again, our contract addendum. I've added here this last slide, the GCAAR Forms hotline. Please do reach out to GCAAR for any forms and specific forms-related questions. While they won't be able to assist with our transaction-specific or fact patterns related to a specific transaction, they are here to provide a resource for how these forms are intended to be completed and integrated with one another. And my contact info is included here too. So of course, reach out with any contracts, client needs, or title legal questions we can assist with. And between our office here at District Title and our partners at MBH Settlement Group, we'll be sure to put you in touch with someone that can directly assist with anything you need here on our side. And again, please do stay tuned as there'll be future forms updates as these changes go into effect and issues arise that we need to adjust the forms for, and we'll do other educational sessions. You can find those on the mbh.com website. Those are all part of our continuing efforts to educate and engage our industry community and help grow your business at the same time. And with that, I wanted to leave some time for any questions anyone may have in the chat, or you can take yourself off mute if you have a question. I'm happy to assist.
Jeff, there is one question in the Q&A from Sabrina. Is the seller compensation form being offered for rentals as well as given before showing?
So all the form updates here, all 11 of those are just in relation to sales. So I don't have the information on rentals at this time. I can pull that for us, however.
Okay. I don't see any other questions coming in the Q&A or in the chat. So thank you everyone for joining us. And again, share this recap with your friends. It will be on our YouTube channel later today. Thank you so much, everyone.
Thanks all. Have a great day.
Thank you, Jeff.
Appreciate it.